Hi, I'm Charlie Roadman, Austin criminal defense attorney, and I'm going to talk with you about expunctions. Okay, so let's take a look at the five categories here. We've got what is an expunction, are you eligible, what if you don't do it, how does it work, and how long does it take? Okay, so what is an expunction? An expunction is a legal process by which all the records of an arrest are deleted or destroyed. Okay, so they're deleted if they're digital records, or if they're physical paperwork, files, stuff like that, they're actually put through a shredder. Okay, it requires a district judge's order, meaning it's not something that even a county judge can do. A district judge, a higher level judge, has to agree to it based on the fact whether you're qualified or not. It isn't a subjective opinion. The judge isn't going to decide that they don't like you or they don't like the facts. It's just whether you're eligible for an expunction. Now, it's not automatic. Defense attorneys get asked all the time, does this fall off my record or does it expunge itself? And the answer is no. It's a separate process. There's no way to get a case dismissed and expunged at the same time. First, you get a case dismissed, then expunged. And then there's no unsubscribe button. Okay, it's not. I'm going to explain as we go on. It's not just as simple as checking off something down at the sheriff's office and it all disappears. It just doesn't work that simply. Okay, so let's look. Are you eligible? Well, to be eligible for an expunction, your case has to have been dismissed. Now, or you won a jury trial. You were acquitted in a jury trial. But most of the scenarios involve some type of dismissal. Now, there are a bunch of different types of dismissals. Okay, so there's like pretrial diversion, deferred prosecution, reduction down to a Class C ticket, which was also deferred. Anyway, there's a handful of scenarios. You'll need to chat with us to figure out for sure whether you're eligible. The statute of limitations has to have run. Okay, it has to have passed. So most misdemeanor cases, there's a 2-year statute of limitations, and you start counting roughly around the time the case is dismissed. There's a little bit of calendaring plus or minus days that we do to figure out when it's legally eligible. But if you just sort of imagine 2 years roughly from the date of it was dismissed. Now, there are some ways, some scenarios where prosecutors or the clerks involved waive that waiting for the statute of limitations. That's kind of rare. You can talk with us about whether they're likely to wait for that period. But most cases, yes, you have to wait the statute of limitations. And then you have to apply for the expunction in the county where it happened, okay, where you were arrested, where the paperwork is. I can't expunge a case in Houston from Austin, for example. Okay. So the next question, what if you don't do it? Okay, what if you just leave your case dismissed? And the answer is the government keeps the records of the arrest and they don't ever delete them. So it lasts forever. Now, private companies then buy and sell that information and make that available to apartment complexes, to job HR departments. Anyway, so the records are out there and they can be seen. So if you were charged with an assault or DWI or theft, something like that, people can see the arrest, and then the record itself should say dismissed. But often it says like deferred prosecution or pretrial diversion, and people don't know that means dismissal. So the wording is confusing to lay people that it's often not clear that your case was dismissed. So the basic principle is you should expunge everything that's possible to be expunged. That's the general rule. How does it work? Okay, so what we do first is compile all the information about your arrest. Okay, so we figure out, get the paperwork, and that often involves contacting the county clerk and ordering files. If it was from a long time ago, they might have already warehoused them. Or we gather all the information. Okay, and then the next thing we do is we identify the agencies that have information about your arrest, and that could be anywhere from 5 to 15 different agencies. And that's a little surprising, but if you imagine you're arrested, okay, APD has your arrest. Now you're taken to the jail. Now sheriff has your information. Then pretrial services now has your information. Then the county clerk now has your information. Then Counseling Education Services now has your information, and then they send that to DPS. Anyway, your information just gets distributed as the case goes on through these 5 to 15 agencies, and that's one of the big jobs of a defense attorney, is to figure out who has that information. Because if you don't tell them to expunge the information, they're not going to do it. So it's like a game to figure out where all this information would be. The next thing that a defense attorney does is files a petition in district court, and that involves listing all the agencies, their contact information, explaining why you're eligible for an expunction, and presenting it to the judge. The next step is the court will assign a court date, so we go to court, and as long as there's no objection or there's no problem, the judge will typically sign the order of expunction. And that then gets sent back to all those agencies who are ordered to delete or destroy the records. And then finally, a defense attorney's job is to make sure that that actually happens, because even though they're ordered by a district judge, these agencies, they have flaws in them, and so sometimes they don't actually comply when they're supposed to. And what happens is we notice that, and we contact them and say, hey, you didn't do what you're supposed to do, and they say, okay, we'll do it. So they don't do it. They don't mess up on purpose. They just, they've got a million things they're doing all the time. So finally, how long does it take? Now, a court date is given to us about 30 to 45 days after we file the petition. That gives all the different agencies that are notified about the court date time to figure out if they're going to object. Okay, and again, they typically don't, as long as you're eligible, but they have to have time to look everything up. And then once the judge signs the order, the agencies have 6 months to actually delete or destroy the records. Okay, so we often get questions like, I have a job interview coming up in 2 weeks. Can you get the case expunged before then? And the answer is no. It takes 7, 8, 9 months for it to be expunged. So plan ahead. All right, that's basically the way this process works. If you have any questions, by all means call us. You can look up your own record on Travis County. Travis County has a website that you can look up your name and see what shows up. We're happy to help get a case expunged. We do it all the time. Let us know if you have any questions.